My understanding is that there's a person logging in from the courtroom at the courthouse, so we'll hold on for a moment until they get logged in.
Come on, baby. So when she comes, let's see, hold on.
We can see and hear you, Deputy.
Oh, I got it.
Yep, you got it. Okay, good morning. I'm Judge Tammy Long Hayward. This is a dispossessory calendar, State Court of Clayton County, courtroom 304. This is November 30th, 2022. And the cases on the calendar have Progress Residential Borrower versus Nicole Torrance, to Darius
Daniel
Washington.
Green sorry, Judge.
And all other occupants. Okay, Daniel Green for
Landlord.
All right. Is someone here on behalf of Nicole Torrance and Darius Washington? I see Nicole. Name is spelled differently than I have on my calendar, but I'm hoping that is, may I hear or see you, the person who's named Nicole, on the screen? Okay. Well, let me finish the call of the calendar. All right, 17544 Forest Parkway Partners LLC versus BW Inc. Markeisha Crossman, Jermaine Crossman, and Candace Wright.
Good morning, Your Honor. Paul Marachnik for the plaintiff.
Okay. All right. Ma'am, Nicole is, are you Nicole Torrance? Okay. Okay. And the last case on the calendar is Nikki Mercy versus Jamal Tandy. Nikki Mercy, I see. I'm sorry.
Good morning, Your Honor. Gerald Bender for the plaintiff, and Ms. Mercy is on the Zoom call.
All right. Deputy, who's in the courtroom?
I'm Regina Upchurch. Regina Upchurch. Progress Residential. Progress Residential.
All right, Mr. Green, is this your witness? Mr. Green has disappeared.
Somebody need to come up here.
Mr.
I'm sorry,
Green,
did he say he's with Progress Residential?
yeah, there's a Regina Upchurch in the courtroom.
Okay,
Is that your witness?
yes.
Okay. All right. So for Progress Residential, this is my understanding TAC and mail took place on June 16th, 2022. Then answer was filed on June 23rd by Nicole Torrance. Having looked at the file and the clerk's information, the answer was filed a day late. So the answer would not be effective in this case, and the court would issue a default judgment based on information and evidence presented by a Progress Residential borrower. Ms. Torrance, do you understand what I've just said?
No. What do you mean by that?
I mean that there's very strict timing issues in a dispossessory. Your answer was to be filed within 7 days of the TAC and mail and the corresponding mail of the service copy, and you filed it a day later than was required. So, yes, ma'am.
I did file it a day late because I had filled out the wrong paperwork, because I was talking to a lawyer and she had sent me the paperwork, and what she sent me was the wrong thing. And then by the time I was up and down at Clayton County, running up and down the stairs, it was too late to turn it in. They said I had to turn it in, and I turned it in the first thing the next morning.
Okay. All right. I'm sorry that an attorney gave you the wrong information, but the answer was still considered late under the statute. Mr. Green, do you have anything on behalf of Progress Residential? Mr. Green,
Yes,
can you
Your
hear me?
Honor. Through today's date, the balance owed is $19,534.27.
Is this a residential property or commercial?
It's residential, Judge, but there hasn't been a rent payment since July of 2021.
Yes, sir. Is this the total amount of rent due? Are there any late fees that are being asked for or any damage assessments?
There's no damage assessments, Judge, but this is all fees up through December 1st of 2022, prorated.
All right. So, Mr. Green, because her answer was filed late, then this is considered a default, and I can give you possession of the property, but you are going to have to pursue the amount of charges in a separate civil suit if you wish to do that, but you can't do it here because she didn't answer. So she's not properly before the court.
I understand, Judge.
So I can give you an instant writ of possession. So
I understand.
All right, so Ms. Torrance, Mr. Green, on behalf of the company, is asserting that you owe close to $20,000 in back rent. However, because you didn't answer properly, you're not properly before the court, so a default will be given. But in a default, I can only give possession of the property. I can't allow for the payment of rental back rent. So in this case, I'm going to grant Mr. Green's client possession of the property. Now, the default does permit the court to give an instant writ of possession, which means that they could take possession of the property today. Have you prepared in any way for that? Because had you answered, the maximum I could have given you was 7 days anyway.
Well, I haven't been there since then. since they
Since-
didn't, because they locked my account to where I couldn't pay. My
Okay.
my lease wasn't up until October, and they locked my account where I couldn't pay any more rent. And I was constantly, I was trying to catch back up, and I was actually paying since April on time, and they locked it in July. And I asked them, why did they lock my account? And they said, because they had sold the property.
Okay.
So I was
Well-
trying to pay my rent. And then, I mean, I haven't been there anyway since August.
Hold on, ma'am. You said they locked your account in July. Well, they
Yes.
filed for dispossessory in June.
They locked it because I paid in June.
Okay.
And I couldn't pay for July. They wouldn't let me pay for July. And when I called them, I told them, I said, I need to pay. And they told me they can't accept my money. And I'm like,
They
how can
can't,
you-
because in June is when they filed for dispossessory. Under the law, if they file for dispossessory, they can't accept payments unless they're paid through the court after that. Okay.
Okay, even if I paid in June?
They just filed June 16th, so I'm not sure whether they filed after you made that payment or what, but that's when they filed. So they're not allowed to take payments after that, because that would negate everything they're saying. Okay.
Okay.
All right.
Okay.
So
Kinda
Mr.
understandable.
Green, do you have a proposed order that you can send to Ms. Heath Fortson so we can do the writ of possession?
I could, does the court want to just do it since you're making findings yourself, or would you rather us send it, Judge?
Ms. Heath Fortson, it's up to you. If we have a template that you want to use, that's fine.
We have a template that I can use.
All right, thank you, ma'am. All right, so Mr. Green, Ms. Torrance, the courts has found in this case that because the answer was late, there's a default in this case. The court is going to grant a writ of possession under the default. That writ of possession will take place today after the court signature. But Ms. Torrance has indicated that she has exited the property prior to the or right after the filing of the dispossessory. Okay. All right. Anything else on behalf of Progress, Mr. Green?
No, thank you, Judge.
All
May
right.
my witness be excused?
She may. All right,
Thank you.
Miss Torrance, you're excused at this time. Thank you, ma'am.
Hello, Judge.
Yes.
Okay, I think I'm standing here and I think these were two different cases because
Okay.
my case number is 2022 CB 01911. And I am with Progress Residential, and we supposed to have our rent paid by today, on or before today. And we are here to pay with, and I have the rental system gentleman is here with us with the check to make the payment. So I think we are talking about two different cases that I'm not with the lady you were just speaking to.
All right. Hold on, ma'am. So Miss Heath Fortson, can you look that case up for me? Because I don't know if that's even assigned to us.
I'm looking it up now, Judge.
Thank you. All right. So ma'am,
Judge, may I be excused?
You may, Mr. Green. The
Thank you.
cases that are on the calendar are cases that we received and defaults, and I'm sorry, we determined that those cases needed a hearing, but there are 5 judges on the state court. And so any of those judges may have received a dispossessory from Progress Residential. It's not just me. So we're going to look up the case and see if that's one that we have. If you were told to pay today, it's not to us. If you were going to make a payment, it's either got to be through the clerk of court or it's got to be through some agreement that you made with the landlord. But that payment would not come to me or through me.
Now, when you say the clerk of court, is that someone here?
Yes, ma'am. But see, I don't know if it's the clerk of state court or the clerk of magistrate court because it depends on where you filed.
It is state court.
Okay, so then what you'll need to do is go down to the first floor of this building, right below where you are. Go down to the first floor. The state court clerk's office, when you come through the double doors, is going to be on your left. You go through those double doors and then they'll assist you.
And they was the one that sent us up here.
I'm sorry, ma'am.
They was the one that sent us up here, right?
Okay, well, we're
Okay.
looking up the case. It's 202. Yes, hold on. It's 2022 CV 01911, and it's Progress Residential Borrowers versus, I believe, Miss Regina Upchurch.
Yes, ma'am.
And Judge, that case was actually before another judge, Judge Parker, and it looks like a consent order. A consent judgment was granted on November 8th of this year.
Okay, so ma'am, that's another judge. That's Judge Jones Parker. I don't know if she's having court today, but her courtroom is right next to mine.
Is that the 305?
Judge Jones Parker, 305 or 303? I can't remember which way the numbers run. 305, yes, ma'am. 305.
Okay, thank you so much for your help.
All right, ma'am. Thank you. Okay. Yes, Ms. Torrance.
How do I handle that? Is that counted as an eviction, or can I still pay them?
No, ma'am,
Or-
it's counted as an eviction. Now, if you want to clear up the back rent, that's between you and Progress, and you can talk to Mr. Green. His name is Daniel Green, Greene, but I don't know his firm name.
Okay, yes, ma'am.
Okay,
Okay, yes, ma'am. Thank you.
you're welcome. Thank you.
Okay.
All right, so the next case is 1754 Forest Parkway Partners, LLC versus BWE Inc., 2022 CV 02092. Mr. Moranchik is here for Forest Parkway Partners, and that's versus BWE Inc., Markeisha Crossman, Jermaine Crossman, and Candace Wright. I don't see any of the tenants presented. So, Mr. Moranchik, I have that the dispossessory was filed on September 24th of 2022 by TAC and mail, and I don't have any response from the parties. So, do you all have a writ of possession form that you wish to use, or do you wish to ask the court to enter the writ of possession in standard?
Thank you, Your Honor. Yes, we've submitted a writ of possession, an application for writ of possession. We submitted it back in October 11th. So that I believe is in the court's file, and we're just waiting for that to be signed.
Okay, so the reason we had set a hearing was when we sent out the court notice, we hadn't heard anything on behalf of the company, which was BWE Inc., which we know is required to be represented by an attorney in state court, but they have defaulted and have not answered on behalf of the company or on behalf of the individual tenants. So the court is going to grant the writ of possession in stanter, and I'll go ahead and sign that today.
Thank you. Ms. Heath-Fortson, Ms. Heath-Fortson, is it possible to get an email copy of that order when it is signed and entered? Or will that be e-served?
It will be e-filed, but I do have your email address, so I'll go ahead and forward that once it is filed with the court.
Thank you so much. I appreciate it. Judge, good to see you. May I be excused, please?
Yes, sir. And thank you for coming in. I know you probably thought it was a little bit of a waste of time, but I wanted to make sure I wasn't going to have a lawyer here from the other side screaming about lack of service or something. So
Yes, Your Honor,
thank
I
you.
understand. Thank you.
No problem.
Bye-bye.
All right. Nikki Mercy, Mr. Bender, Gerald Bender on behalf of Miss Mercy versus Jamal Tandy. And I see Jamal Rashid. I'm sorry. Are you also Mr. Tandy?
Yes, ma'am.
Okay. All right. So Miss Mercy filed, and it was personally served on November 9th of 2022. And Mr. Tandy also filed an answer on November 16th of 2022. The Miss Mercy is requesting back due rent in the amount of $11,400 according to the court document. Collection costs of $500, late fees of $1,020, interest of $471.12, attorney's fees of $1,314.13, and writ up to the date of judgment or vacancy. All right, Mr. Bender on behalf of Ms. Mercy.
Yes, Your Honor, I had filed 3 exhibits with the court that were accepted by the court. And Exhibit 3 actually has an updated amount of past due rent. Because another month has, rent has continued to be due through the date of judgment. This case, you're right, and those amounts, I'll get to those amounts in a second. First off, I think the defendant's answer is legally insufficient. It does not deny any of the allegations. So we would certainly, ask the court to move for judgment on the pleadings. That said, Your Honor, this is a case where the lease was entered into in May of 2021. Mr. Tandy did not pay any rent after October of 2021, so there are 13 months of past due rent. The lease is pretty clear. The lease was submitted as plaintiff's exhibit number 1. And the lease is clear from its sections various sections that not only is rent due on the 1st of the month, but if rent is not paid by the 5th of the month, a late fee is due. The lease also provides for damages, interest, attorney's fees, and collection costs and court costs. If you look at plaintiff's exhibit 3, which I also provided to Mr. Tandy, it shows that the amount of past due rent is actually $12,350. The accumulated late fees over 13 months is $1,105. The interest calculated at the legal rate of 7% per Georgia law is $553.60. Attorney's fees per OCGA 13-111 A2 is $1,425.86, and the court costs, process server, collection expenses, etc., $500. The total we're seeking today is $15,934.46, as set forth in plaintiff's exhibit 3, which we maintain all amounts are liquidated. I have Miss Mercy here, and I can ask her questions.
Just one question, Mr. Bender. So I was looking through the lease, and I did see that the rate of rent was $950 per month. But I was looking for, and I see the late fee of $85 in addition to that, but I was looking for where the lease provides that interest will be paid and collection fees.
If you look at, Your Honor, in section 25 of the lease, it calls for damages in the event of a default. And certainly interest would be a form of damage because the plaintiff was without the rent, with the use of the rent money as provided. So I would submit that the interest is an item of damages allowed under section 25 of the lease. Your Honor, if you're so inclined to not agree, we will strike that prayer for interest, which would.
All right. I generally don't give interest on dispossessories. I'm fine with court costs. I'm fine with late fees, the rent due and owing up and through the date of departure of the dispossessory. So those things are fine, but I just generally don't give interest on that. All right. So go ahead, sir, Mr. Bender. You said you wanted to examine Ms. Mercy.
Yeah. Ms.
Mercy,
Yes.
raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right, Mr. Bender.
Yes, Ms. Mercy, when is the last month you received rent from the defendant?
October of 2021.
Okay, you've received no rental payments or any other payments from him since October of 2021?
I have not.
Okay. Did you reach any agreement with him regarding any abatement of rent or postponement of rent whatsoever?
Nope, just urging him to pay, which he has yet to do.
Okay. Your Honor, that's the only question I have for Ms. Mercy.
Mr. Andy, did you have any questions of Ms. Mercer, or did you just want to tell the court your side of the dispute?
I guess I'll just tell my side.
Okay, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
I do.
All right, go ahead, sir.
Miss Mercy is correct. I have failed to pay rent. Excuse my dog. She originally filed a disposory or eviction dispossessory on January 4th, 2022. Your Honor, your video is frozen. I don't know if you can still hear me or not.
Yes, sir. And I
Okay.
think everybody else's video is frozen on my end, but this is better now. Can you
Okay.
can you see me and hear me? All right.
I can. So I was saying she originally filed on January the 4th, 2022. And I answered that. But we had I was granted assistance, renter's assistance. And in fact, they paid one of my bills, but they promised to pay Miss Mercy, but never paid her. I don't offer that as a legal defense, but that is the case. At this time, Miss Mercy and a close friend of mine are in talks in her buying the property. So Miss Mercy just spoke to her about that, and we had talked about that, and I was hoping that could be given a time frame in which, if it did not happen.
Well, sir, that the one has nothing to do with the other.
Okay.
So as hard,
Okay.
I did dispossessory in magistrate court for 4 years, and it is a hard thing to do because you have to tell people that they're going to have to leave their homes. But the way the law is in Georgia, as long as you're in possession of a property, then the landlord is owed rent. Now, if there are other
Yes,
things that are argued that may offset the payment of rent, then those things can be taken into consideration. But if you fail to pay, that is the basis of dispossessory law in Georgia.
I believe your mic is
That you
frozen
cannot
again.
stay on rent. I'm sorry.
Okay.
It's just that you cannot stay in the property if you fail to pay rent.
Understood.
Because you answered, I am permitted to give you 7 days to vacate on a dispossessory. You could negotiate more time if Miss Mercy or Mr. Benda are willing, but they're not required to give you more than 7 days to vacate the property. And I will issue a writ that will be effective on the 7th day after this hearing. And at that point, you have to be out of the property.
You froze again, if you can hear me. Judge Hayward, you're frozen.
I believe Judge Hayward is experiencing some maybe internet connectivity issues, so we'll just give her just a second. She may have to log back on.
Yes, ma'am.
Property, or they can exit.
Your Honor,
Yes.
we see you. Back on,
Okay,
yes,
good.
ma'am.
All right. Thank you. All right. So did you have anything else, Mr. TND?
I do not.
Can you just
Yes.
repeat what you were in the middle of saying, just because I think that because of the connection,
Yes, ma'am.
disconnection, we didn't hear you.
I was saying that the court is only permitted to grant 7 days for an eviction. So once we have this hearing and I sign the writ, then 7 days from now, the Mr. Benda and Miss Mercy will have possession of the property. So you have to be out by that time, or they can affect a marshal's.
No.
Eviction.
Okay.
Your Honor, I can, excuse me, this is Gerald Bend again. I can explain that to my client without problem. What
I would just want Jamal also to understand, so there are no surprises, and because this is the law, you know, and it's been going on for over a year, been more than kind.
So Nikki, are you not interested in the purchase anymore?
That's a separate issue.
Okay.
Your Honor, we can, as far as any attempts by the
So,
defendant.
Mr. Tandy, I'm being
Yes,
evicted.
ma'am.
Even if somebody purchases the property, that won't keep you from being evicted.
Yes, ma'am.
All right. So, Mr. Benda, did you have a document that you wish to present to?
Yes, I will send it to Ms. Heath Fortson. Proposed a money judgment. I will remove the interest and with the updated figures for the money judgment. And it'll be, I can combine that with a request for a writ of fiery facias as well. You know, we'd like to proceed with that.
Okay. So, yeah, the court is inclined to.
But I will
Well,
submit that to her today.
Okay, so once you have submitted that, then I'll sign it. And then Mr. Tandy, I just advise you that you want to prepare yourself because you don't want someone to have to put your stuff on the curb. Okay. All right. Yes, ma'am.
Sir, Mr. Benda, I just text you if there was something that you could bring up. I don't know if that's something that we can bring up in court. We briefly discussed it on the phone. I'm sorry to interrupt. Like I just.
Your Honor, what she's referring to, if there were any damages, there've been some physical damages to the house during the tenancy, and
Okay.
I realize it's not part of this dispossessory action at all, and we would have.
So I don't know if there was a security deposit in this case, but if there, okay, because you know there's a whole section of the law that requires a walkthrough, and then if you're going to keep a portion of the security deposit for damages, then you can keep that based on what the law requires there be the walkthrough. So.
Yeah, I bought it and he was living in there at the time.
Okay, so you brought a property and you were torn to the lease that was there and didn't require another. Okay, I get it. All right.
Yeah, you live and learn.
But yeah, property's a difficult thing. There's a lot that goes into managing it and owning it.
That's
All
right.
right. So, Mr. Benda, I'll look forward to that order, and I'll go ahead and sign off on that as soon as I get it. Mr. Tandy will get you a copy of that also. Miss Heath Fortson, do you have, Mr. Tandy, did you want to provide like a mailing address that you could receive it, or an email address? An email will probably be easier because we electronic file everything here.
Sure.
Yeah, Your Honor, I already have Ms. Heath Fortson's email address.
No, I was talking about Mr. Tandy.
Okay, I'm sorry.
So, Mr. Tandy, did you want to give us an email address for Ms. Heath Fortson?
Sure. It is KOSHER. The letter T is in Tom, V is in Victor, @gmail.com.
So I have koshertv@gmail.com. Is that correct?
That is correct.
Okay. All right. So this.
I'm sorry, I
concludes-
have one quick. If there are damages to the property upon him vacating, is that a criminal matter?
Well, that might be a civil matter, but you can talk to Mr. Benda about that.
Hold
Okay.
on now, come on.
I just want to make sure my place is safe. That's all. Thank you.
All right. So at this time, I'm going to conclude the hearing. Thank you all, and you'll be receiving the orders by email.
Thank you, Your Honor.
Thank you, Your Honor.